Okay, so there we go. Let's talk about the primary drivers of IUU fishing. So there's a number of drivers that we identify at a global level driving IUU fishing. Some of them are more related to industrial fisheries, some are more related to small-scale fisheries. But we'll go through them, discuss them one by one, and then at the end I'd also like to hear if these are the types of drivers of IUU you're seeing in the Pacific, or if there's additional drivers that you might identify. So the first and one of the most important drivers that Francis touched upon is the economic driver for IUU fishing, the money, of course, big driver of IUU fishing, particularly in industrial fisheries. So in order for money or economics to be a driver of IUU fishing, what needs to happen is that the expected benefits from illegal fishing need to outweigh the expected benefits from legal fishing, right? That's fairly straightforward. And the way we sort of consider this, whether a vessel will engage in IUU fishing, is we do something of a cost-benefit analysis. We look at the potential benefits of engaging in IUU fishing versus the potential costs of engaging in IUU fishing. So some of the benefits of engaging in IUU fishing might be, of course, you can catch if you are exceeding your quota, if you are, going into areas you're not supposed to be in. There's the potential to get a larger catch. You also might get a higher price if you are going after high-value resources like toothfish, like tuna, which are protected, and again, you are overfishing those resources. And again, as Francis mentioned, the cost of fishing may be lower if you are engaging in IUU fishing because you're not necessarily having to pay license fees and safety, costs for safety, labor, etc., taxes, and so on. So we balance those expected benefits against the expected costs. And those include a number of factors. So, of course, in the first place, what happens if you're caught? What are the penalties? So, am I going to get a fine? Am I going to get my catch confiscated or my vessel confiscated potentially? Am I going to be banned from fishing? Am I going to have my subsidies taken away from me? All of these are, of course, potential penalties that could befall you for engaging in IUU fishing. We also have to consider the cost of avoiding being caught, the cost of avoidance activities, which can include, of course, corruption, bribery. That could be a cost. Also, potentially the cost of transshipment. If you want to obscure where the catch came from when it's landed, you might have to pay for that. So all of these are potential costs of avoidance that you have to take into account. And then finally, we have to consider the probability of detection. So how likely are you to be caught? Of course, even if the penalties are high but the probability of detection is very low, then you may still take the risk, right? So all of these are factors we need to take into account. And then one other factor, there we go. One other factor, which has also been identified when it comes to this cost-benefit analysis is the potential impact on your moral and social standing in society if you're caught. So quite apart from, the reputational implications of being caught, so potentially have an economic cost, particularly if you're relying on, for example, people in your community to help you with the fishing operation. There's a sort of backlash against you engaging in IUU fishing, and then you may have to go further away, pay more to get that assistance in your fishing operation. So all of these elements should be considered when we're thinking about whether industrial vessels or any vessels really will engage in IUU fishing. And many of the other drivers that I'll talk about, actually, we will see that they do, have a relation to this in that they either will lower the costs of illegal fishing or drive up the benefits of illegal fishing. Another important driver is this issue of inadequate legislation and particularly inadequate sanctions. So this is a very nice graph created by Samela and his colleagues, which gives a very nice illustration of why we really need to make sure that before we do anything else, before we focus on things like enforcement, we have to first make sure that our legislation is up to date and that we have adequate sanctions to ensure that we are, actually deterring IUU fishing if the vessels are caught. So if you can see in this first case, this vessel was caught catching Patagonian toothfish illegally, and the expected benefit, if they had sold this fish, was $504,000. The penalty that was levied on them was $87,000, so that's quite significant. And if we add that penalty to the total cost of the fishing costs, we can see that we get a total cost of $526,000. Now, that total cost, of course, is higher than the expected benefit. So in that case, we can see that the expected penalty in this case, the fine, is actually providing some sort of deterrence mechanism to engaging in illegal fishing. Because if you are caught, you are not going to make a profit. In these other fisheries, however, things are quite different. So here we have the expected benefits, here we have the very low penalties, and when we add these penalties to the total cost of fishing, we see that the total cost is less than the expected benefit. What is the consequence of this? You can catch all of these vessels engaging in IUU fishing. You can have the best enforcement and monitoring in the world. You can have 100% sort of catch rate. But this fine is just not going to deter this fishing. They're still going to make a profit. And so you are already playing a losing game if you don't have fines that are sufficient to actually drive the costs up to the point where they exceed the expected benefit. So that's extremely important to keep in mind when we're thinking about trying to deter IUU fishing, having adequate sanctions. Then a major driver of IUU fishing is, of course, distant water fishing. This is something which Julie raised yesterday, whether we think that the actions of certain developed countries have led to IUU fishing or are the cause of IUU fishing in developing coastal states. And in relation to distant water fishing, we can certainly say that is a problem, that is a risk, because not only is distant water fishing a lot of the time, in the high seas and in the waters of developing coastal states, notorious for overfishing and depleting fish stocks, which can of course have the knock-on effect of increasing illegal fishing. There's been studies showing that these vessels also do engage in illegal fishing themselves. So this is a study from West Africa. In the study, the authors were looking at the behavior of EU fleets and Chinese fleets in West Africa, and they found that there was significant illegal fishing going on in these fleets. And the consequence of that was that not only, of course, was this depleting the stocks, but also the amount that they had paid for access to the fish stocks, which already wasn't adequate considering the value of those stocks, ended up just being a fraction of what was actually being taken because of the illegal fishing. So this is a big problem. This is a really big problem when it comes to illegal fishing, because on the high seas, often in the waters of coastal developing states, MCS capacity is lacking, and enforcement capacity is just not necessarily there to address this problem. And related to distant water fleets, we have the issue of fishery subsidies, because distant water fleets would just not be able to function, a lot of them, without subsidies. Because of course they have to go, really far out, they have to go into the high seas, they go to the waters of other states, that uses a lot of fuel on top of other costs. And so without having these costs subsidized, these distant water fleets really wouldn't be able to function. And so fishery subsidies in that sense, because they fund distant water fishing, are a driver of IUU fishing. They also are a driver of IUU fishing because they increase fishing capacity and overfishing. By building more boats, by keeping more boats on the water when fishing is actually not profitable, of course you do end up incentivizing overfishing because there's too many boats chasing too few fish, and there is incentives to cut corners in order to make quotas. Similarly, because many fishery subsidies can take the form of loans, and of course with loans you have to pay them back. Again, that can incentivize overfishing and IUU fishing in order to repay those loans. And also, I mean, very importantly, subsidies prevent disinvestment from the fishing industry because, you know, it's in general terms, if you're not making a profit, you will leave the industry, but, you know, subsidies cover your costs. Even when you're not making a profit, you may stay in the industry for that reason. And I will talk a lot more about fishery subsidies on Friday. Then a big one, of course, is capacity constraints. As Francis mentioned earlier, we have these vast ocean areas, which, particularly on the high seas, are very, very difficult to police. And there is variability in the performance of RFMOs, so while some RFMOs do function well, others do struggle to fulfill their obligations to conserve the stocks under their control. And so this also feeds into this problem that we have where we have capacity constraints when dealing with IUU fishing. Technological advances, as we know, can help with monitoring. They always help with enforcement, however, so you know you can sort of see all of the IUU fishing that's going on now, but you can't necessarily go out with a boat and actually arrest those vessels, so that is one of the drawbacks. But of course, technological advances are important to at least help us monitor these fleets in these areas. And then, as I mentioned earlier, one of the problems is that if is not having strong up-to-date laws and regulations, and part of that can be, of course, a lack of capacity to draft these, and also potentially a lack of training of judges and legal practitioners to actually deal with these cases effectively. Then another very important driver is the issue of flags of convenience. Now, not all open registers badly manage their fleet. I think we have to acknowledge that, you know, there are some open registers where there is good management. But a lot of the time, what we see with open registers is that they are sort of lax laws and regulations on things like IUU fishing, safety, environmental pollution, etc. And also that these flags lack adequate monitoring, control, and surveillance capacity. And because of that, they tend to attract unscrupulous operators who want to take advantage of this, who want to just do whatever they want. And so, you know, this is a problem when you have these states not properly exercising their flag state control. Some of these flags of convenience, we have seen some of the most notorious ones have actually specifically registered vessels involved in IUU fishing and related crimes as well. Some of them have been specifically set up for that purpose, like the recent Eswatini flag open register. Eswatini, or formerly known as Swaziland, is a landlocked country, of course. Doesn't have a lot of capacity to control fishing fleets, that's for sure. And so really that one was set up purely for the purpose of registering some of the most notorious IUU vessels and the worst vessels. So that's the one side of flags of convenience. The other issue is that because there are so many flags of convenience, this does increase the ability for vessels to flag hop. And that ultimately, as Francis was showing with this FB Viking case, does obscure the ultimate beneficial ownership of vessels. It does make it much harder to track down those ultimate beneficial owners and hold them accountable. So then moving on to the other side of things, the more of the small-scale fisheries, one of the big drivers that we see there is this issue of food and livelihood insecurity. Again, this is something that I'm going to talk a bit more about tomorrow when we talk specifically about small-scale fisheries, but just to introduce this sort of idea, what often becomes a sort of vicious cycle. What's important to understand is that a lot of the time when we're thinking about small-scale fisheries, they do tend to be, at least initially, victims of IUU fishing from the perspective that, industrial fleets have much more capacity to fish and overfish, leading to stock depletion. That in itself creates food and livelihood insecurity, but then, of course, the response to stock depletion is that we put in management measures, which in the long run should help to rebuild the stocks, but in the short term as well, because they restrict access to resources, can lead to food and livelihood insecurity as well. And so we do end up seeing this vicious cycle where fishers, when they are facing these problems, these insecurities, may turn to negative coping behaviors such as IUU fishing. But in general, IUU fishing in the small-scale sector is quite complicated. It has very different drivers to the large-scale sector, and that's something I'll discuss in a bit more detail tomorrow. Then we have the issue of organized crime, and I'm not so sure that this is such a big issue in the Pacific, but we do in many parts of the world do have criminal networks, in fact, driving IUU fishing. So this is an example from my home country, South Africa. This is abalone. And abalone is a very high value resource. And because of that, the stock is massively depleted. There are management measures trying to properly manage it, rebuild it, but it's just impossible because we have actually organized gangs that recruit local people, recruit local fishers to go and collect this abalone for them because they can make huge amounts of money from it. And we are always seeing these sort of raids of these abalone warehouses where they just find tons and tons and tons of this dried abalone. On the other hand, we have a situation where IUU fishing can sometimes lead to the issue of maritime crime. And one of the big I suppose, biggest cases of this, most notorious cases of this, is the piracy that we see in places like the Gulf of Guinea and the Gulf of Aden, which is very much driven by overfishing and IUU fishing in those areas. So, like I said, I'm not sure about the Pacific. I think that, you obviously don't have these big issues of piracy and things like that here, but I would be interested, if you have any examples of, how organized crime can drive IUU fishing or vice versa in this area. Be interested to hear that at the end when we discuss some of the drivers in the region. Another big driver, of course, is governance problems. Things like poor governance and corruption, as we discussed before. If you can, for example, bribe an official to look the other way, that is one way that you can avoid being caught for IUU fishing. That's potentially a potential cost to avoid being caught. So that's, one issue. Also, in certain places, the fisheries is just very badly managed and full of corruption. So there's also the issue of the fishing access money and power dynamics. So again, I'm not so sure this is such a big issue in the Pacific because I know that you do negotiate as a bloc when it comes to access, but in places like West Africa, there isn't a sort of united front when it comes to negotiating access agreements. And so what tends to happen is that those who are paying for access have all the power, whereas those who are giving access don't have much power, so they can't negotiate higher prices. And if they try to, the country trying to get access can just go to the neighboring country and say, okay, well, they won't give me access, will you give me a lower price? And it becomes a bit of a race to the bottom. Fishery subsidies we've already discussed. The way that the way this relates to governance is that a lot of the time fishers are lobbying for more fishery subsidies, once you start to give them, it's very difficult to take them away, of course. Politicians don't want to be unpopular, they don't want to take money away. And so, once you start to give them, you do end up in this difficult situation where the fishing industry is lobbying you for subsidies, or more subsidies, or to retain the subsidies. And that has governance implications. And then we also have things like the lack of knowledge. If there's just maybe not such a good understanding of this problem, then there may also be no political will to address the problem either. And they did this very interesting study on the priority of the Sustainable Development Goals, leaders' top priorities. And what they found is that life below water, unfortunately, right at the bottom here, does not appear in the sort of top priorities of leaders around the world. Again, this will depend, of course, on where you are. In the Pacific, of course, fishing is such an important part of the culture, part of your livelihoods and food security, that I think that this probably is not the case for the region. But in a lot of other places around the world, life below water is just not seen as an important priority for global leaders. And finally, something I don't really need to talk to you about is the issue of poor coordination mechanisms. So I'm thinking here in this illustration particularly of regional cooperation, which of course you're really good at, pooling assets and resources to ensure that you are properly monitoring and the regional fleet and not duplicating efforts. But I think another thing to also be aware of here is that poor coordination mechanisms at national level can also be a problem when it comes to addressing IUU fishing effectively, because as we've seen throughout this throughout the program that we are going to be covering in the next 2 weeks, IUU fishing and fishing in general, of course, is a multifaceted and complex issue that we need to approach from many different angles. We need to also consider things like safety and labor and trade, and so it's really important that at the national level that we're all speaking to each other in the different ministries, so we can have a coordinated response to IUU fishing, so we have all the information that we need, so we're not duplicating it. Okay, so I'm going to take a little break from speaking there and ask you about what the IUU fishing are in your country. And I want to do this as a word cloud on Mentimeter, and I hope this is going to work. So I know that the Wi-Fi isn't so great in here, but if you are able to log in either on your computer or your phone, you can either log in with the QR code, or you can go to this address and put in the password, and you can give up to 5 answers. 5 different drivers, what you consider the main drivers of IUU fishing in the Pacific region, and then we'll put it up and have a little discussion about it. So I'll just give you a few minutes to answer, and then we'll put up the results. Has everybody managed to log in yet, or not? Yeah, everybody's managed to log in? Okay, not yet. Okay, has everybody who wants to answer answered? Or was it some people still? I see we have 12 people. Okay, so let's just wait a few minutes. Try and get to 15 at least. Okay, I actually see a lot of corruption, bribery, low salaries, which of course is feeding into that. So that's interesting. Didn't actually expect that. Wow. Okay. So yes, a lot of different ideas there, which is great. So criminal behaviors, geopolitics. I see colonialism. I see very interesting. Yeah, absolutely, and that of course feeds into the distant water fishing aspect as well. High licensing fees, interesting. So yeah, there was a way to avoid that. Historical prosecutions. I'm not sure what the relevance is of historical prosecutions. Anyone want to expand on that? They've just not been a good deterrent. Okay. Okay, great. Yeah, that's very interesting. I see that actually. Yeah, things like corruption and bribery and then things like that have actually been actually quite significant in the region. So good to know going forward. Okay, great. All right, good. So, yeah. Any- Anyone want to expand on low salaries? Quite a few people have said it, so yeah. Yeah, I'm just asking you to. Yeah, I'm not saying you should have done it here, but if anyone wants to expand on that on low salaries for who, I'm assuming. Yeah. Yeah. That was my assumption as well. Oh, I see outdated legislation is also a big one. So yeah, that's certainly something to look into because that really should be the first thing you look at when trying to deter IUU fishing, and then you can deal with the enforcement aspect. Just the money, okay?
Yeah, I think the drivers for offshore IUU might be different from nearshore or coastal IUU.
Sure. Yeah, that's a good point. Maybe we
Because
can.
I think that's
Yeah.
what's confounding some of this.
Yeah, sure. No, that's a good point. So maybe tomorrow we can actually look at the drivers of because I will be talking about the drivers in the small scale sector. Maybe we can have another sort of word cloud on that. Yeah, good idea. Anyone else want to comment? Before we move on, we can also discuss this during the breaks and so on. Okay. Okay, good. All right. So, in the interest of time, let's quickly move to the legislative framework. So now, of course, what I'm dealing with here is the international legislative framework. I don't know. Okay, I've lost my others. Okay, good. There we go. So yes, so we're dealing with the international legislative framework, of course. Many of you may not necessarily work with this framework, but you will, of course, be working with domestic law, regional law, and this framework is very much where a lot of those laws will come from and be incorporated into regional and domestic law. So it's important to understand this. Okay, so when we're looking at international fisheries law or international law in general, we have a lot of different conventions, a lot of different guidelines, a lot of codes, a lot of resolutions, and so on. I've divided into two separate sort of circles here, because in international law we have, when it comes to conventions and instruments and guidelines, we have what we call hard law, which is binding international law. So these are the treaties that are concluded between states that bind the parties to those conventions. Of course, the sort of overarching, what is often termed the Constitution of the Oceans, the overarching oceans and fisheries law, which forms the basis of much of the fisheries law that follows, is the United Nations Convention on the Law of the Sea. Related to that, we have the United Nations Fish Stocks Agreement, which of course is the agreement that deals with straddling and migratory stocks and the need to develop regional fisheries management organizations to manage those stocks on the high seas. UNCLOS has a couple of really important provisions when it comes to fisheries. One, of course, is the creation of the exclusive economic zone. That's, of course, where it comes from. Allows states to declare 200 nautical mile exclusive economic zones in which they have the exclusive right to exploit the resources in those zones, but also the duty to conserve those resources. The other important provision in UNCLOS when it comes to fishing is its provisions on high seas fishing, and in particular the fact that states have the right to fish on the high seas, but also the duty to conserve resources on the high seas, and very importantly that flag states must control their vessels. And of course we see that that is not always the case, often not the case when it comes to flags which are flags of convenience. And there have been sort of attempts over the years to reinforce this obligation, for example, in the FAO compliance agreement, which does try and sort of ensure that flag states do exercise jurisdiction over their own vessels and properly control them on the high seas. But again, that convention did not really do very much when it came to improving this problem. And subsequently we've had other instruments like the guidelines on flag state performance, which is a voluntary instrument, which is also trying to do the same thing. So as I said, we have this hard law, this binding law in international law, and then we have what is called soft law. So this is voluntary law, basically. It's not technically law, it's voluntary. It's codes and guidelines. But what's interesting about international law is that it's very much a consensual system. It's a very political system. States have to consent to be bound. There's no international police force, right? There are international courts, but they often don't have the ability to enforce their judgments. And so really when we're thinking of international law, we're thinking of consent. And so in some instances, it doesn't always matter if the law is sort of binding or not, because at the end of the day, if you get taken to an international court and told to comply with the agreement, you may have some moral and political and social pressure to do so, but no sort of actual enforcement capability exists, except for the World Trade Organization, which does have the ability to enforce its judgments. So today I'm going to be talking about, unfortunately I won't be able to talk about all of these conventions and soft law because there are just too many of them. So what I'm going to do is focus on the conventions that are specifically focused on IUU fishing, including the Port State Measures Agreement, which is the first international agreement set up to deal with IUU fishing, as well as the International Plan of Action on IUU fishing, and the recently adopted transshipment guidelines. But before we get there, I just want to emphasize something, because I want you to understand how all of this international law fits together. Because as I said, it's a consensual system. There's no sort of police force. There's no overarching body controlling all of this. And what that means is that when it comes to international law, we have what are called different regimes. So for example, we have the fisheries regime. It's a set of norms and laws and enforcement mechanisms on a particular subject. So we have the fisheries regime, we also have the trade regime, pollution, safety, all of these different regimes, which sometimes like to think that they are self-contained, but that's not actually the case. They interact with each other. And so one of the big things that they try and do in international law is try to harmonize these different agreements and these different frameworks. And this is why I want to sort of draw attention to the trajectory of fisheries law and how it's developed in international law. So, over here we have UNCLOS, and in the sort of 1990s, 1980s, 1990s, we have a few codes and guidelines which are created which provide sort of overarching views of fisheries law. They're very broad instruments. They cover a lot of different subjects. The FAO Code of Conduct, for example, is a very, very influential agreement, despite being a voluntary agreement. And it covers just about every area you can think of when it comes to fisheries, from the environmental, the social, the economic, the regulatory, the legal. It covers, everything. So these instruments are very broad. Same with the FAO International Plans of Action. They're a bit more specific, but again, they are fairly broad in their coverage. And then as we get into the 2000s, we see more and more specific agreements being adopted. So, for example, there's a whole lot of agreements on safety and labor on fishing vessels being adopted, the Code of Safety, the Small-Scale Vessel Guidelines, the Work and Fishing Convention, the Cape Town Agreement. The Port State Measures Agreement is also adopted in 2009, dealing specifically with port state measures to prevent IUU fishing. We have the voluntary guidelines on flag state performance, the small-scale fisheries guidelines, the voluntary guidelines on catch schemes, also the SDGs should be there as well, the Sustainable Development Goals, and then more recently the transshipment guidelines and the agreement on fishery subsidies. So as you can see, we're just getting more and more specific, and these agreements are often giving effect to certain parts of certain provisions in the earlier agreements, the broader agreements. So because fisheries are this complex and multifaceted issue, as I've mentioned, we do need all these agreements. That's really important that we have all of them, because we do need to deal with just all these different facets of the problem. But we also need to find ways to harmonize these and avoid fragmentation, so that we don't have to have one agreement overriding another, for example, which of course states are not going to be happy about, given that they have negotiated these agreements, they've consented to these agreements, they've changed the domestic law based on these agreements, and then you tell them that, oh no, it's being overridden by a more recent agreement, they're not going to be very happy. And so we have to find ways to harmonize this framework. And so, this is how this framework all sort of fits together. Some of the international conventions are related to each other, so UNCLOS and the UNFCA are related. The FAO instruments also all build on the FAO Code of Conduct. In other instances where they're not related, they may include clauses providing that their provisions should be interpreted in accordance with principles, rights, and obligations in other agreements to harmonize them that way. And some instruments also specifically incorporate laws from others. So that definition that Francis talked about earlier, the definition of IUU fishing, has become very influential, has been incorporated in many, many different international instruments, and also, at a regional level with RFMOs as well. However, it is important to understand as well that some of these agreements are more influential than others. Some of them deal with problems which are more easily resolved than others, or it's more easily accepted that there needs to be a resolution to this problem. And I've talked quite a lot about the failures in flag state performance, and something like the Port State Measures Agreement, for example, was adopted as a response to the failure of instruments like the Compliance Agreement and others to have tried to ensure that flag states will control their IUU fishing. that's how it all fits together, and I'm going to quickly go over a few of these IUU instruments and what's in them. So the International Plan of Action on IUU Fishing was one of the first very comprehensive instruments adopted specifically on IUU fishing by the FAO. As I said, this is a voluntary instrument, but it has become very influential, particularly its definition of IUU fishing. And what it does is it essentially provides almost a blueprint to tackle IUU fishing effectively. It's, as I said, it's quite broad. It has a lot of different areas. I'm not going to go too much over the definition of IUU fishing because Francis has already talked about it. The only thing I want to mention about this definition is that even though it has very much become the accepted definition of IUU fishing, it is also often criticized as being too broad and too confusing. And this is particularly because of the second part of the unregulated fishing definition, which notes that part of this IUU fishing is fishing in waters where there are no applicable conservation or management measures. Now, the problem with that, of course, is that the people who are responsible for creating management measures are governments, right? It's not the fishers themselves. And yet fishers are often punished under this agreement when there are attempts to address the problem of IUU fishing, particularly small-scale fisheries, as we'll discuss more tomorrow, are targeted when IUU reforms are put in place, even though they are often unregulated through no fault of their own. So this is one of the big problems with this definition, and something to be aware of for sure when you see it. Now, as I said, the International Plan of Action on IUU fishing includes many different areas. It has the legal area. It encourages the ratification and implementation of international instruments, the creation of appropriate national legislation, and effective sanctions, of course. So a lot of this is actually dealing with trying to address some of these drivers we discussed earlier. It has provisions on monitoring, control, and surveillance, having effective MCS, tackling flags of convenience, and also controlling transshipment. It has provisions on traceability and records, so you need to keep records of fishing vessels, authorizations to fish, and also unique vessel identifiers, such as the IMO numbers. It encourages cooperation between states, at national level as well, and also technical assistance for developing countries to tackle IUU. Of course, it also deals with RFMOs and encourages compliance with RFMOs and RFMO membership. And finally, it deals with trade. So it says that states should avoid providing fishery subsidies, prevent trade in IUU caught fish, and implement port state measures. And so that's where we get onto the Port State Measures Agreement, which was adopted in 2009. And this gives effect to certain provisions of the FAO Code of Conduct, but also the, of course, IPOA IUU. This is a binding instrument. So the other one was voluntary, this one is binding. And one thing to just be aware of when we discuss this agreement is, of course, as I'm sure you know, port state control applies only to foreign flag vessels, whereas flag state control, of course, is when you are controlling your locally flagged vessels. And that's quite important because the PSMA, as I said, was adopted as a response to flag state failures to control IUU fishing. And because of that, there's a lot of sort of pressure put on the PSMA to sort of be the instrument that will address IUU, but it's not possible. It has loopholes. It cannot be a panacea. So that's very important to remember. Although it is an important instrument, it is useful. It cannot, single-handedly resolve the IUU crisis, which is kind of the perception in some circles. The way that it works is that foreign vessels, of course, request entry to a designated port, and then if there's a kind of suspicion of IUU fishing, that vessel can be denied port, or you can authorize entry and you can inspect that vessel, or of course, if you don't think it's been engaging in IUU fishing, you don't inspect it, it just uses the port. But if you are worried that it's been engaged in IUU fishing, or potentially you just are have certain number of vessels you need to check, then you will inspect it. And then if you detect IUU fishing, you can deny the use of port, and you can also take other measures in conformity with international law, such as confiscating catch or levying fines or whatever. And then once you have made that decision, it's been denied port, you need to notify the flag state, relevant coastal states, RFMOs, and so on. Now, this agreement works on risk assessments, so you don't have to inspect every single vessel that comes into your port under this agreement. You only have to inspect the number of vessels that will allow you to complete essentially to meet the aim of the agreement to prevent, eliminate, and deter illegal, unreported, and unregulated fishing. So, as I said, this agreement has a lot of benefits, but also some drawbacks, which mean that it's not sort of the be-all and end-all, the panacea to solve IUU fishing. So benefits include, of course, that it prevents the landing of IUU caught fish and therefore its entry into markets. It can also close ports to IUU fishing. So particularly if you have all the sort of ports in an area closed to IUU fishing through this agreement, you can make the vessel go further away to land its catch, so you will end up increasing the costs of IUU fishing. So that goes back to that cost-benefit analysis, where we're trying to drive up the costs of IUU relative to the benefits of IUU. Because, of course, if you're going to a different port, you're using more fuel, and potentially you have to pay your crew more, and so on. This also allows you to take any effective measure as long as it's in accordance with international law, which does allow for additional deterrence mechanisms apart from just denying port. And as I said, it works on risk assessments, so that makes it a little bit easier to implement. However, there are a lot of challenges as well, and the big one, of course, is capacity constraints. Now, I don't know how many vessels are coming into your ports every day. Perhaps it's fishing vessels, perhaps it's a very low number. Perhaps you're able to inspect all of them if necessary. But for some ports, there are hundreds and hundreds of vessels coming in every day. And if you only have 2 or 3 inspectors, of course, you cannot actually inspect all those vessels. You probably can't even inspect all the vessels that you think are risky. So in that sense, capacity is an issue. And related to that is the fact that states can't control external risks. So what that means is, as a state, you can't control how many vessels are coming into your port. You can't control how many of those vessels are potentially engaging in IUU. One of the ways in which you might know that is if that vessel is an RFMO IUU list, or if it's been designated as a non-cooperating country by the US or the EU, for example, for IUU fishing. That could be a basis on which you inspect it. And states really can't control how many of those vessels are coming into their ports. It also doesn't apply to local vessels. Like I said, this is only, of course, applying to foreign vessels. And so what we see happening in some cases is that there's a legal transshipment from foreign vessels to local vessels. We see this in Ghana with the psycho fishing that goes on. And then those vessels will land the catch. And so that's kind of a way that you can evade this agreement. It also may require high levels of national interagency cooperation. Of course, when a vessel comes into port, we know that there's a lot of different agencies that have to inspect it: customs, immigration, potentially labor, safety, and so on. So you just, you're adding another layer to this, and that, of course, requires a certain amount of cooperation. It also relies on extensive information exchange to be effective, because part of the reason why you might inspect a vessel, you might deny port, is if a coastal state next door to you has already inspected the vessel, found evidence of IUU fishing, and denied port. But you won't know that unless you have some way of communicating that. So one of the issues is that if you have good information exchange between all the states in an area, the organizations in an area like RFMOs, the flag state, and so on, you can sort of do a much better assessment of the risk of this vessel. And so this is why this agreement works much better if you have extensive information exchange. the FAO has actually addressed this problem somewhat with the creation of this global information exchange system that they've created, which does allow for this communication to go on. And also relating back to the external risk of vessels, the IUU vessel list created by RFMOs are often quite limited. They only cover a fraction of the vessels engaging in IUU fishing, and so this can be a bit of a difficult basis if you're using this to if you're relying on this to assess risk. And then very, very quickly, because I know we're running out of time, I just quickly wanted to talk about the new transshipment guidelines that have been created by the FAO, because of course this is seeking to plug a massive regulatory gap that we have globally. Transshipment is just very poorly regulated globally, and this does of course facilitate IUU fishing. You're putting all the fish into one vessel from different boats, and that means that you can perhaps obscure those fish that are illegally caught. Of course, as we know, transshipment is necessary for some industries to survive, so there is a need to regulate it, while not, of course, completely abolishing it. And so this is where these FAO guidelines come in for states that have outdated transshipment laws or don't have any transshipment laws. These provide sort of a minimum set of standards that states can use to address IUU, or to address the issue of transshipment, to create laws regulating transshipment, which, as we said, is the first step when it comes to addressing IUU, is creating strong, robust, and up-to-date laws. And what these voluntary guidelines essentially do is they suggest that countries use transshipment and landing declarations. They also suggest that states put in place conditions for transshipment authorizations. So, for example, a vessel should have VMS, an IMO number. It should notify the transshipment. It should, report after the transshipment, and the state should also have sufficient MCS capacity if it is going to authorize transshipment. So these are just these guidelines that have recently been created and are a useful guide for states who are wanting to better regulate transshipment to deal with IUU. Okay, so that was just a very quick overview of some of the IUU conventions. Unfortunately, couldn't go over everything because, as we saw, international fisheries law is very extensive. But we will be dealing with some of those conventions that I mentioned later in the week and next week, as they pertain to the specific sort of areas which they are trying to cover, like trade or safety. Okay, so thank you very much.